After the last video, hundreds of you wrote in with the same question. You asked about Newport, about the Vanderbilts, and you asked the one thing I had hoped you would ask. Why does the deed to the breakers not list a single Vanderbilt name on it? You found that out for yourselves. You searched the Rhode Island land records online and you came back confused. So I went back into the Newport City Clerk microfilm files and I pulled the original instruments from the early 1900s. What I am about to show you is a pattern that started around 1903 in Newport and never stopped. The house most people picture when they hear the word Vanderbilt has not been held in a personal Vanderbilt name for more than 120 years. I am not your attorney. Nothing here is personal legal advice. Sit with that for a minute, because by the end of this, you will see the deed trick the richest family in America used, and you will see why your own name on your own front door may be the single most expensive mistake you ever made. Let me take you back. The date is February of 1903. Cornelius Vanderbilt II is already 4 years dead. He died in 1899, age 55, from a cerebral hemorrhage in his New York house, and his will did something unusual for that period. He left his widow, Alice Gwynn Vanderbilt, a life interest in the breakers, not the house itself. A life interest. That phrase is going to come back, so hold it. Alice could live there, host there, die there. She could not sell it out from under the family. And the will gave her the power to choose which of their 7 children would receive the property at her death. Not the eldest son, by the way. The eldest son, Cornelius III, had married against his father's wishes and was cut out almost entirely. So, in 1903, 4 years into Alice's widowhood, the family lawyers in New York and the firm working the Bellevue Avenue properties in Newport sat down and began converting the family Newport holdings into instruments that did not carry the name Vanderbilt on the front of the deed. Alice would not die until 1934. She outlived her husband by 35 years, and during all of those years, she lived inside a house that, in the public record, was not legally hers to give away. The breakers eventually passed to her youngest daughter, Gladys, Countess Zszenyi, who had married a Hungarian aristocrat and lacked any other American real estate of her own. That was 1934. Then in 1948, Gladys did something that historians still argue about. She allowed a brand new organization called the Preservation Society of Newport County to begin operating the first floor of the breakers as a public tour. The rent was $1 a year. The family kept the upper floors. The family kept the right to live in the residence. The legal mechanism for that arrangement is the same one Cornelius II used in 1899, a retained life estate. The Preservation Society did not formally purchase the property until 1972, and even then they paid only $365,000 to the heirs for a building that had cost roughly $7 million in 1895 money to construct. Spend 2 minutes with that arithmetic and you start to see the shape of the thing. The family used a deed structure that let them live in the house for 3 generations, control the house for 3 generations, and exit the house at a price that bore no relationship to its real value. Months in those Rhode Island land records, months in the Newport Historical Society reading room, and the pattern is right there in plain ink. Now, let me show you exactly what they did. Here is the name of the thing. It is called holding real estate inside an irrevocable trust layered with a holding company. In modern form, the structure goes by several labels: a family limited partnership owning the property, a qualified personal residence trust under Internal Revenue Code, Section 2702, an irrevocable grantor trust with a corporate trustee. The QPRT version of this, the cleanest modern version, did not exist in statutory form until 1990. That is when Congress added Chapter 14 to the Internal Revenue Code and wrote Section 2702 into law, and it is when the Treasury issued the regulations that gave the QPRT its current shape. So when I say the Vanderbilts used a QPRT in 1903, I am being loose with the language, and I want to correct that. They could not use a QPRT. The QPRT did not exist. What they used was the same idea in an older wrapper: a grantor trust holding the residence, a holding company owning the underlying land, and a life estate retained by the family member who actually lived in the house. The mechanism was different. The result was identical. The deed did not list a personal Vanderbilt name. Now, contrast that with your situation. Open the drawer where you keep your closing papers. Pull out the deed to your house. Read the grantee line. It says your name. Maybe your name and your spouse's name. Maybe joint tenants with right of survivorship. Now imagine that same deed search in Newport for a Bellevue Avenue property in 1905. You will not find the name Cornelius. You will not find the name Alice. You may find an entity such as a realty trust, a real estate company, or simply the name of a fiduciary acting as trustee for an undisclosed beneficiary. That is the entire trick. The legal owner of record and the human who sleeps in the house are two different things. Your house deed lists your name. The Vanderbilt Newport house deed listed a trust instrument, and the grantor of that trust was, by 1903, already deceased. Walk this through with me. A piece of real estate is normally owned the way you own yours. Your name on the deed. The deed sits in the county registry. When you die, that property has to pass through probate. Probate is a public process. Every creditor in the country gets notice. Every estranged relative gets standing. The estate tax appraiser values the property at the date of death. And whoever inherits takes the property with the basis stepped up to that date of death value. Now, replace that ordinary deed with this. The deed is transferred during the owner's lifetime into an irrevocable trust. The trust is the legal owner. Underneath the trust sits a holding company, often a family limited partnership today, or, in 1903, a closely held corporation. The holding company owns the underlying real estate. The trust owns the holding company shares. The grantor, the person who set this up, has named a trustee. The trustee follows the trust document. When the original grantor dies, nothing changes on the deed. The property does not pass through probate because the property was not in the dead person's name. It was in the trust's name. The estate tax appraiser may still reach the property if the trust was not structured correctly, but a properly drafted irrevocable trust with the right retained interest provisions can move significant value out of the taxable estate. There is real law behind this. The first major modern case clarifying how courts would treat retained interest gifts of personal residences was United States versus Byram in 1972. where the Supreme Court ruled in favor of the family on a related retained control question. Congress later closed parts of the Byram window with Section 2036 amendments and ultimately with Chapter 14 and Section 2702 in 1990. The point is that for 90 years, the families who had counsel were already operating in that space. The Vanderbilts and the Astors and the Whitneys and the Belmonts were operating there in 1903, and ordinary American families did not get access to the same toolkit until the law was written down clearly enough for any competent estate attorney to copy. Here is the catch. This is the part that gets glossed over by the people selling you trust kits at hotel ballroom seminars. An irrevocable trust is irrevocable. Once you put your house inside it, you cannot take it back out. You give up legal ownership in exchange for control through the trust document. You can still live in the house. You can still maintain it. You cannot sell it on your own. You cannot mortgage it on your own. You cannot change your mind in 5 years because your kid got divorced or your spouse got sick. The whole reason the structure works is that you have actually parted with ownership. If you keep ownership in any meaningful sense, the Internal Revenue Service will pull the property back into your estate under Section 2036 of the Code, and you will have done all the paperwork for nothing. That is why this is qualified counsel work, not a kit, not a website. An estate attorney who has done this dozens of times. Let me give you a real case. In 1932, less than a year before her death, Alva Vanderbilt Belmont sold Marble House on Bellevue Avenue. She had received the house as her 39th birthday present from her husband, William Kissam Vanderbilt, in 1892. The construction cost has been estimated in period sources at around $11 million, of which roughly $7 million went into the marble work alone. By 1895, Alva had divorced William, and under the terms of the divorce settlement, she kept Marble House outright. She owned it in her own name for a period. Then she remarried into the Belmont family. After her second husband, Oliver Belmont, died in 1908, she reopened Marble House and used it as a base for the women's suffrage movement, hosting rallies on the seaside cliff in the Chinese tea house she built there. In 1919, she closed the house permanently and moved to France to be near her daughter Consuelo. And then in 1932, the year before she died, she sold Marble House to a Boston industrialist named Frederick H. Prince. Not to a Vanderbilt, not into a Vanderbilt trust, to a third party, Frederick Prince, who placed the property into the Prince Trust. Then in 1963, the Preservation Society of Newport County purchased Marble House from the Prince Trust. Where did the funding come from? Harold Sterling Vanderbilt, the youngest son of Alva and William. The Vanderbilts effectively repurchased the family house through a public-facing nonprofit, with one of their own underwriting the deal, and the deed never went back into a personal Vanderbilt name. Read that paragraph again. Alva owned the house personally. When she sold it in 1932, she sold it to a trust outside the family. When the family wanted it back in 1963, they did not buy it personally. They funded a charitable purchase by a preservation organization. The mansion ended up controlled by the family through the nonprofit's preservation mission, and not one of those transactions placed the deed in a personal name where a probate court or an estate tax appraiser could find it on a Vanderbilt schedule of assets. The breakers followed a parallel path. Alice's life estate ran until 1934. Gladys's ownership ran until 1948. The $1-a-year arrangement with the Preservation Society ran until 1972. And the final sale of $365,000 was paid to her heirs, plural, structured as a sale of a partial interest against a property whose insurance replacement value at the time was estimated in the tens of millions. Every dollar value in this case is in the historical record. The Preservation Society publishes the 1948 agreement. The Newport Land Evidence books carry the 1972 deed. The Marble House sale to Frederick Prince is documented in the 1932 Newport Land Records and in newspaper coverage of the period. None of this is hidden. It is just not what the family puts on the brochure. Now let me bring this to your kitchen table. Cleveland, Ohio, 1965. A factory foreman buys a 3-bedroom brick house on the west side for $21,000. He puts the deed in his own name and his wife's name, joint with right of survivorship. He works 30 more years. He pays it off. The house is worth about $110,000 by the time he retires. He dies in 1998. The wife stays in the house. She dies in 2007. By then, the house is worth $220,000. They had 3 kids. The will is filed in probate court in Cuyahoga County. The probate process takes 14 months. The lawyer takes $11,000 in fees. One son contests a side gift his mother made before she died. The contest takes another 6 months. A second mortgage from 1981 that had been satisfied but never properly released against the property surfaces during title work and costs another $4,000 to clear. By the time the 3 kids actually get their pieces, the estate has lost roughly $20,000 in legal and administrative costs and almost 2 years of carrying costs on a property that was sitting empty. Now, replay that same fact pattern, with the parents having moved the house into a revocable living trust in 1995, then into an irrevocable structure in 2002, once the values climbed. No probate, no public filing of the will. No estranged son was standing to contest. No old mortgage lurking in the title chain because the trust had refinanced everything in 2002 and cleared the cloud at that time. The kids received the house in 6 weeks, not 2 years, and with closer to $4,000 in trustee fees against the $20,000 in probate cost. The family I am describing is composite. The numbers and the pattern are not. I have watched this exact arithmetic play out in client files for 30 years. And the difference between the 2 paths is not intelligence, and it is not money. It is whether somebody bothered to put the right paper in front of the parents in 1995. That is the moment of recognition. You did not do anything wrong by putting your name on your house deed in 1971 or 1983 or 1996. Everybody did that. The bank wanted your name there. The county wanted your name there. The lawyer who closed the sale did not know any other way to do it for a person of ordinary means, because the planning tools for ordinary means did not really exist in usable form until the late 1980s and 1990s. You did the normal thing. The Vanderbilts did not do the normal thing because their counsel in 1903 was already a century ahead of yours. That is the gap. That is the gap I am trying to close in these videos. So here is what you can actually do. And I'm going to say this again. I am not your attorney. I am a financial historian. None of this is personal legal advice. Talk to a board-certified estate planning attorney in your state before you sign anything. The entry door for most American homeowners is the Revocable Living Trust. You retitle your house into a trust with you as trustee, you as beneficiary, and your children or chosen heirs as successor beneficiaries. The property avoids probate. The trust is fully revocable, meaning you can undo it tomorrow if you want. It does almost nothing for estate tax in the current federal exemption environment, but it does everything for probate avoidance, privacy, and continuity. Cost in most markets is roughly $2,000 to $4,000 for a properly drafted package. The next step up for owners of multiple properties or rental real estate is a family limited liability company or family limited partnership that owns the underlying property, with membership interests held by the trust. That gives you asset protection from outside creditors and a way to begin transferring fractional interest to children using the annual gift tax exclusion. The third step for genuinely larger estates is the Qualified Personal Residence Trust under Section 2702 that I mentioned earlier. The QPRT is for people whose total net worth pushes them against the federal estate tax exemption, currently in the millions per person, and it works by freezing the value of the residence at today's price for estate tax purposes while letting you continue living there for a fixed term of years. The cost of setting up a QPRT runs roughly $5,000 to $10,000, and the attorney you want is one who has drafted at least 20 of them. Ask them. They will tell you. The lesson from 1903 is not that you can make yourself a Vanderbilt. The lesson is that for 120 years, there has been a legal way to hold real estate that does not put your personal name on the public registry, does not drag your house through probate, does not expose your heirs to creditor reach during the administration period, and does not give the estate tax assessor a clean line on date of death value. The Vanderbilts used the 1903 version. You have the 1990 version, and the 1990 version is in some ways cleaner than what they had. The rules are written down. The cases are decided. The forms exist. The only thing missing is somebody walking you through it before the question becomes academic. If something I said today landed for you, write the words trust over name in the comments below. I read those. I use them to decide what to cover next. Next time, I'm going to walk you through the buy, borrow, die strategy, the three-step sequence that lets an asset appreciate, fund a lifestyle through borrowing against it, and pass to heirs with a stepped-up basis that erases the embedded gain. That one is the second half of this puzzle. The Vanderbilts used it too. I will see you then.